What companies can do about policy engagement?
I would say track national transposition choices. And while this is a maximum harmonization directive, the development risk defense permits member state variation for specific product categories. So member states must notify the Commission of existing measures that they wish to maintain by 9 December of this year. And new measures require a notification and a waiting period. I would say engage early with consultations where they exist. So we know that some of them have already passed. I mean, for example, we've seen the Netherlands, Sweden, Denmark, Finland, just to name a few, that have already closed. But there will be some coming in the future. So when there's an opportunity to engage in a consultation, you should absolutely do so. Member states are transposing the directive now. So businesses affected by potential development risk defense variations, particularly in the pharmaceutical and medical device sectors, they should absolutely engage with national policy makers during this window. Additionally, the Commission will set up a publicly available database of final court judgments delivered under the directive. So monitoring this database, that will help provide early visibility into how national courts are interpreting key provisions of the new EU PLD.
If you were to mark one specific takeaway for our audience on PLD, what would that be?
So the new Product Liability Directive represents a seismic shift in the balance between claimants and defendants, and frankly, not a balanced one. The framework that operated effectively for over 40 years has been replaced with a regime of presumptions, of burden shifting, and ambiguous terminology that creates significant uncertainty and exposure for businesses. The rule of law requires that those who allege harm prove their case. But this new PLD inverts this principle in critical respects. So claimants who assert difficulty in proving their claims can have defect or causation, or even both, presumed in their favor, even before potentially establishing that they have a viable case on the merits. So the ambiguities in key terms, so there's obvious malfunction, there's the excessive difficulties, another one is plausibility. There are these various terms in the PLD that can be very ambiguous, and they will become clear through years of litigation, during which businesses face unpredictable exposure. So preparation beats reaction. The directive applies to products placed in the market after 9 December 2026. That is the compliance deadline. But the work, so mapping exposure, reviewing documentation, stress testing disclosure readiness, reassessing insurance, that all must begin now.
Thank you very much, Elizabeth Ann. Thank you for that discussion. Thank you very much for watching the conversation today about Product Liability Directive. Please follow us for more information about third-party litigation funding, class actions, and Product Liability Directive. Especially for you, there is also a presentation prepared by Elizabeth Ann in a good-to-know format. Please swipe and watch the presentation as well. Thank you very much.
Thank you.
Thank you.
Sure.